These are the facts. In the present two appeals, the first appeal was by the first defendant in the civil suit heard by the Judicial Commissioner, JC, whereas the second appeal was by the plaintiffs in the same civil suit. The first defendant was dissatisfied with the JC's decision to allow the plaintiff's claim against it and dismiss its counterclaim, while the plaintiffs were dissatisfied with the JC's decision to invoke Section 66 of the Contracts Act 1950, CA, and, consequentially, to order restitution to the original position's 3 pieces of landed properties that originally belonged to the plaintiffs, which were the subject of the suit before the High Court. The plaintiffs' pleaded case was that they had allegedly executed sale and purchase agreements, SPA, to transfer the properties to the first defendant at the office of the second defendant, an advocate and solicitor. The second defendant had represented to them that the documents that had been prepared and to be signed were loan documentation. The plaintiffs averred that the documents signed by them were for money-lending purposes and to pledge the properties to 2 moneylenders as security for a loan of Rs 1.25 million. In essence, the plaintiffs' cause of action against the respondents was that the SPA in respect of the properties were sham documents in disguise for an illegal money-lending transaction. The JC found that the plaintiffs and the first defendant were in a money-lending arrangement. The SPA as well as the supplemental agreements entered into were illegal and void under Section 24 of the CA. The JC also found that there was no misrepresentation by the second defendant. Hence, the present appeals. The decision, allowing the first defendant's appeal, dismissing the plaintiff's appeal. While the provisions of Section 100A of the Moneylenders Act 1951 that the proof of a single loan at interest would raise the presumption of a moneylending business by the lender, it was trite law that proof of carrying on a moneylending business required evidence of some degree of system and continuity in the moneylending transaction, which was absent in the present case. The court found that the evidence was not sufficient to prove interest payments and that crucial witnesses were not called. The onus is on the plaintiff to prove each vital element of their claim, and the primary premise of the plaintiff's claim was not established, making it an error on the part of the JC to make orders against the defendant. The case involved a claim of misrepresentation, but the court found that there were certain undisputed and/or admitted facts that showed that no full statement of fact was made by the defendant. The plaintiffs failed to prove that the defendant made a full statement, so their claim was not sustainable. The evidence on the existence of a money-lending transaction was unsatisfactory and far from sufficient, so it was not necessary to consider whether the defendant had knowledge of the transaction. The plaintiffs were aware of the binding effect of signing documents and knew the difference between a money-lending agreement and a sale and purchase agreement, and the defendant had explained the contents of the documents before they signed. To conclude, the court found that the JC made a wrong finding that the second defendant was a party to the alleged money-lending transaction, but the JC did not make any errors in law or fact in concluding that the second defendant did not commit any misrepresentation to the plaintiffs in inducing them to execute the documents. The JC's finding was purely a matter of fact, and the claim against the second defendant was dismissed. To know more,